Call by eminent lawyers, a whole lot of people, about reforms in the judiciary. In fact, some of them say both in the bar and the bench is needful now to tackle corruption. Remember those calls about special courts here and there, matters about terrorism. It all just goes on. Well, this time we're joined by Mr. Omodara Samson, who is the Publicity Secretary in the Nigerian Bar Association, Ikeja chapter. Thank you for coming on this morning.
Thank you, my brother.
Well, it may be amazing. I know you may have also heard all of those calls and recommendations, even those of some SANs, the CJN. How did you internalize all of this?
I think first and foremost, there's need for us to go to the basics. The training of lawyers being shown out by Nigerian Law School, both at the universities and Nigerian Law School. We need to go further as lawyers to see that lawyers are given the proper training.
Are you faulting the training they're getting now?
It is, no, the salary is falling day in, day out.
Oh, okay.
There's need for us to go further to ensure that lawyers that are being shown out to the public are well trained.
How do you, any example that, what made you say that?
I'm talking about the curriculum, the entire curriculum being done as the one now. There's need for improvement on it. We expect lawyers to engage in more practical training under seniors who have the moral standard, the etiquette,
okay,
to train them.
Okay, compare what's going on now with when you were there, when you went to the university and law school. What's the difference?
Well, it has to do with personal decision. Like myself, I undertook training under seniors, not even 1, 2, 3. There's need for us to go back, because whether as a lawyer, whether you are in the bench or at the bar, you are first and foremost a lawyer called to Nigerian bar before you decide where you want to be. As a lawyer, you can decide to be in private practice for the rest of your lifetime. You can decide to go into corporate practice. You can also decide to go into the bench as magistrates and judges. But first and foremost, you have to start as a lawyer, and that is where the training starts. I'm emphasizing it that there's need for us to do something about it. Lawyers, after their law school training, should be made to have at least 2 years compulsory training, pupillage, under assistant lawyers, for them to have the experience.
2 years compulsory
training. At least,
training.
I'm saying at least.
But wouldn't that extend? I mean, law school, doing law is already 5 years. Wouldn't that extend the training time to about 7 years, almost the same time for doing medicine?
Yeah.
No, I'm talking after they are being called to Nigerian bar. Before you start practice on your own as a lawyer.
For you to do another compulsory
training, pupillage.
But is it possible for any lawyer to just start out on their own
It is
like
possible.
that?
The law allows that. There's need for the amendment of Section 24 of the Legal Practitioner Act. After you are being called to Nigerian bar, there's need for you to undergo pupillage, compulsory pupillage. That was the situation before 1984. And what we are seeing today in legal practice is a kind of how will I call it, the exposition of what has started as far back as 1984. Either to 1984, it was compulsory for 5 years. You must have pupillage for 5 years before you can open your chambers, and that allowed then proper training. The lawyers who are experienced will be able to pass down on to younger lawyers the training they've acquired over the years.
But what has training got to do with reforms? I am
saying is, if you have seasoned seniors who are well established, well trained, that training will permeate onto the junior. Whether you are at the bench.
Are the seniors that you're suggesting that the juniors learned from, they're already seasoned, as it were. They're already trained, as it were. Are they the ones, is it the juniors that is responsible for the need for reforms as it stands?
What I'm saying is this. I am not saying that. But what I'm saying is this. You cannot give out what you don't have. Never do that could go a bit. You cannot give out what you don't have. As a senior, if you learn under a senior, that the training will have been impacted into you. Definitely, if you have your own chambers, or where if you are at the bench or at the corporate practice, that training will also go with you. That's my suggestion.
The reason why the question is important is we're looking at reforms in the judiciary.
If that is an aspect of the reform.
Okay, but the reason why reforms has come to the fore is because of the apparent rot which in the judiciary right now, which is fueled by corruption, as it were. And that's a major part of this reforms that we're talking about. This is not perpetrated by the juniors. It's not perpetrated by those who are just coming up. So that no matter the training that you get, if you lack a conscience or if you lack morals, there's no amount of training that will bring it in, is there?
I'm saying is an aspect that I've just suggested.
Okay.
There are other areas which we have to look into.
Okay.
Even as seniors, if you are found wanting, I'm not exculpating the seniors that they are not culpable. Some of them are even worse than some of us who are just coming up. If you are found wanting, there should be procedures in place to checkmate all these things and punished erring members of the bar appropriately.
Are you
both
bothered,
on the bench?
Are you bothered at all that corruption is even mentioned in the judiciary, such that people are talking about, well, something really needs to be done to address this problem, because if the public loses confidence in the judiciary, that's like doom for the society.
Judiciary is also part of the society. Corruption is endemic everywhere.
Yeah,
it's not in the judiciary alone.
Yeah, but it's only this sector that is called the last hope
of the common man. That is where the issue is much serious than other sectors, which must be tackled headlong. That is what I am looking at too. The issue of corruption. Whoever is found wanting, whether you are SCN or you are the CJN, you are the chief judge of any state, they should be punished accordingly if facts are situated and proved before Nigerians, whether in the court or anywhere.
Okay, last year, towards the end of last year, there was a lot of brouhaha in the judiciary, the National Judicial Council's misadventures, perceived misadventures and all that. Based on what's happening and the recent renewal of the term of the acting president of the Supreme Court, I mean, what does that say? PCA.
President of Court of Appeal.
Of the Court of Appeal. I mean, what does that say of the decision then to reform?
Well, the NJC, in its wisdom, recommended Justice Ayosalami's suspension. Then it was approved by the president. The same NJC recently also recommended his reinstatement, but that has not been followed. I wouldn't know the reason behind it. I'm not part of NJC. I'm not part of the decision-making organ of this government. I wouldn't know what lies behind such decisions. But I think.
But what does that say of the situation in the judiciary? Is the judiciary moving forward
all
or
is
going
not
backward?
Well with the judiciary. That is very obvious. All is not well. All is not well with the judiciary, and something has to be done urgently to save the nation from.
You suggested one aspect of reforms that you'd like to see, the training of younger ones. In fact, you even set a training time, as it were, for younger ones, compulsory training time, yes. For fresh lawyers, as it were. But what other reforms would you like to see?
Well, I need to also talk about the years for the appointment of judges. Now, presently, it's 10 years post-call experience. But we all know that a lawyer's 10 years post-call experience may not have gathered both the stamina in terms of to carry on the job of a judge, and the experience may not also be there. I'm also suggesting that probably the year should be reviewed upward, like 15 years post-call experience for High Court judges, 20 years post-call experience for Court of Appeal judges and the Supreme Court judges, for them to have experience in their fields, choosing the areas of law they've ventured into.
Come to even think of it, before we even go to this other matters, access to justice. I mean, there are those who say, yeah, much as it may be touted that the judiciary is the last hope of the common man, but the common man, in true sense of the word, cannot even access. I mean, it's getting so expensive lately, you can't get justice unless you've got some, at least relatively deep pockets.
Well, our training as lawyers, we are trained to engage in pro bono cases. And these are part of reforms that Nigerian Bar Association should also put in place, or the Legal Practitioner Privileges Committee should also put as one of the criteria for the award of Senior Advocates of Nigeria. You should have engaged in some number of pro bono cases. That is, you must have rendered free legal services to indigent Nigerians. Aside from the Legal Council established by law to assist the indigent Nigerians, lawyers should also be enjoined to engage in pro bono cases. assist less privileged Nigerians who are unable to pay for services.
Even like the Office of Public Defender.
Like what
is that program?
Like what obtains in Lagos. There's the Citizen Mediation Center. There's the Office of Public Defenders in Lagos to assist less privileged Nigerians to ensure that they are not denied of their rights when such rights are being trampled upon by opponents in the country.
But do the lawyers really need someone to mandate them to carry out pro bono cases?
It's part of our training at Nigerian Law School. We are enjoined to, in fact, first and foremost, as a lawyer, your service is not to look at money, but it's just because of the economic situation in this country. By our training, we are trained to render services to Nigerians, despite the fact probably they cannot afford their services. But because of the economic aspect of it, you don't have to you have to cater for one or two things as lawyers. You need to take money from your clients. But first and foremost, our service is to ensure that justice is done to all Nigerians.
What would you say the NBA as a body is doing to bring back this ideals of being a lawyer?
Can I hear you?
The NBA, what are they doing to bring back the ideals, the original ideals of being a lawyer?
These are issues that as the National Executive Council of Nigerian Bar Association, these are issues that ought to be raised and trashed out effectively. Because we are complaining of declining practice from legal practitioners. We have to look at what are the causes. How do we checkmate some of these causes? These are issues that we have to be deliberated upon at the National Executive Council of Nigerian Bar Association to ensure that this declining downward practice by legal practitioners are checkmated.
Are lawyers being distracted? Are they distracted from that path? There was a time when you say my learned colleague. It's like when you hear that word, a learned gentleman, it's a big word. I mean, right now it's as if you hardly find people saying this is a learned gentleman.
Honestly,
are lawyers being distracted?
Honestly speaking, we have problem in legal profession. I must confess to you, just like other professions in Nigeria. It is difficult now to see your colleague on the other side. He tells you something and you believe him. It's actually very difficult, except the few ones you know that you can actually vouch for the integrity. Lawyers do a lot of things, and these are issues that the disciplinary measures put in place by Nigerian Bar Association should be meted on those erring legal practitioners. It's difficult to see your colleague, even in court. So I'm speaking from the bar. It's now difficult to believe your colleague. And it's an offshoot of what happens in the larger society. So it's not really a problem peculiar to lawyers.
Yeah, we've had the NBA president speak in very clear terms about corruption in the judiciary. But why do you believe that this cleansing will start? Some would say that if the head is clean, somehow, it will help clean the body as well. Can you confidently say that this head is clean enough to be able to ensure the reforms or make sure that the reforms that we want are actually seen in the sector?
I am not too sure. I can say yes. There's need for us to have a leader, both at the bench and at the bar, like we have the president of the Nigerian Bar Association, the CJN, the president of Court of Appeal, the chief judges of all the states. There's need for us to have bold men on those seats who will take bold decisions, not minding who is God. You take those decisions once you know that somebody is wrong, whether you are the chief judge, whatever the measure should be taken against such persons. Until we have such persons at the helms of affair, both at the bar and the bench, then the judiciary will not move forward.
One other matter that, of course, is in the public domain, which leaves a lot of jaws dropping, they don't understand what's going on, is the recent matter we hear concerning Cross River State elections. Also reported was that the CGN had queried the judge. Then there was one major report asking him to reverse that decision, and then the query follows suit. And in today's headline, I'm trying to see which paper it is now, it says court judgment. Let me just see if I could reach for it. Court judgment, CGN. Let me see. I'm just trying to see if I could get it. Look, yeah, that's it. Cross River governorship poll, judge silence on order. And you ask yourself, you thought that these things were clear cut, straight to the point, and now it looks as though can it be said that some politics is going on with judgments? That would be a sad commentary, wouldn't it?
Well, I may not be able to say whether there is politics in what is going on with that order or not. But the CJN, even ordinarily, a judge is enjoined to, on a very, very rare occasion, churn out ex parte orders. Ex parte orders when the other party has not been heard. The other party must be given fair hearing. If a matter is filed in court, the essence of an adjudication, a proper adjudication, is for the other party to be heard, for the other party to be in court to hear the other side, how they are imparting. But where the other party has not been heard, another is shown out ex parte, the other party has been shut out. And that was the situation in this situation. And the CJN has that power administratively to have queried the judge. Why did you give this order when the other party has not been put on notice? What is expected of that judge was to have ordered that the other party be put on notice and adjourn maybe the next 2 or 3 days for the other party to come to court and explain his or her own side of the story before a proper adjudication can
because in this case, the other party says they're not aware.
They are not even aware
of any of such orders.
It appears surreptitiously somebody just went to court, got one order overnight, and expect that order to be obeyed. It's not done.
But the former CJN has spoken about this matter, saying, listen, they all have to be taken seriously. The way they grant ex parte orders really has got to be considered. But we'll see it again.
And I also think that this judge should be investigated. If actually there is some politics has been insinuated, underwent with the giving of the order, it should be sanctioned. If it's investigated and it is found out at the end of the day that there's some factors, external factors that affected the giving out of the order, it should be sanctioned.
That request for the investigation of the judge makes me wonder why the CJN would make this statement that the NJC is bogged down by sundry roles that tend to distract it from its primary role of formulating broad policies for the judiciary.
Well, it's one of those things we've been talking about all this while. The problem are too multidimensional for NJC. Multidimensional in the sense that the primary role of NJC is not being played out, so to say. It's been bogged out. The NJC is now being bogged down by all other problems. Just like we are talking about this order being shown by the judge. The NJC has to investigate, find out its culpability or otherwise, and probably met out appropriate punishment on it.
So
these are other issues.
Does that mean there should be more bodies?
No.
Forming of more committees or more councils or more bodies?
Maybe the membership of NJC should be increased, and probably committees should now be set up. Committee on discipline of judges, committee on appointment of judges, committee on this, and a broad-based committee to harmonize the reports of this committee.
Okay, let's ask a question. Do you think the NBA is effective in monitoring its own lawyers?
Well, I won't say 100% effective, but on our part, I can speak for NBA Ikeja branch, of which I'm the public secretary. We on our part have been trying to ensure that our lawyers of NBA Ikeja branch probably falling into the standard expected of us as lawyers. If you are not ready to do what the law expects from you as a lawyer, then you fall out. We have been trying to do that on our part, but I cannot say that I'm not castigating the national body, because lawyers are too many in this country. It's not even difficult. It's even difficult rather to, at our local level, to really organize ourselves and ensure that things are done properly. Not talk of the larger body of them.
Is it that do you have an idea of the population of lawyers? Let's use Ikeja for instance.
Well, in our own branch, we have close to say 150,000. No, is it up to no, maybe 3,000-4,000 lawyers within the Ikeja branch. I may not be precise in the number of figures, but we have up to that.
3,000-4,000 is a lot of lawyers.
Within the Ikeja branch.
And you're able to monitor them effectively.
We are trying our best. We are not saying. We are trying our best to ensure that things are done properly.
You spoke earlier on about winning confidence in the head and the leadership of the judiciary as it is, and that you're looking at them increasing, broadening the leadership as it were. But steps already been taken. Do they give you confidence? For instance, in this Cross River issue now, and the steps already been taken where it seems the justice has been miscarried, as it were, does it give you confidence to say that, yes, from the look of things, it seems the right things might be done eventually?
Well, that is what I have said earlier on, that we need bold leaders to take bold steps. Like this judge, his culpability or otherwise has to be investigated. And if he's found culpable, he should be sent out of the seat. Because the seat, you are not there. When we appear in court and we say, my Lord, nobody is anybody's Lord. But a judge personifies God on that seat. You are expected to show that judgment, justice to all men, irrespective of their creed, irrespective of their status. You are expected. You are not expected to look at the faces of anybody. Show out justice the way the cases are being presented before you. And until we have judges, we have leaders who are bold enough to, set aside all these mundane sentiments and do what is right.
Would you say the country is ready for that? Because it's one thing for a judge to do what he or she believes is right, to do what God will do, assuming God were handing out judgment. It's another thing for the people to be able to accept it. Would you say the society is ready?
Well, that is where the right leadership is required. If we have the right leadership, we also have the followership that will follow them the way the leader wants the followership to be.
Do you have any, since you're in publicity in the NBA, any means, any medium whatsoever that any aggrieved member of society can get across to you concerning an errant or errant lawyer?
Yes, we have that within the branch. If you are aggrieved by what a lawyer has done to you, all you need to do, put pen on papers. I address it to the chairman, disciplinary committee of Nigerian Bar Association Ikeja branch. That will be taking some meetings with a bar clerk. That will be looked into, and we'll look at if a prima facie case has been established against such a lawyer. He will be invited to hear his own side. They will make recommendation to the national body if that lawyer should be designated.
Any records of any previous recommendations and perhaps what has been done?
Well, we have recommended a lot of lawyers who we thought within our own knowledge that a prima facie case has been established against such a person. They've been sent to, I wouldn't want to mention names on here, their names have been sent to national body for disciplinary actions.
Or can you put a figure to it?
Well, to my knowledge, like 3, 4, 5 since I joined the ESCO.
When was that?
2 years ago.